Recording in progress.
And you have your first witness ready to go, State?
Yes, we do, sir.
Then let's go ahead and bring in the jury.
No, because she just, no. Yeah, no.
All rise as the jurors enter the courtroom, please.
Ms. Reese, did she go to the bathroom? Everybody can be seated. By show of hands, anybody assure me that they have not had any conversations with anyone? Also, no one has done the outside research, is that correct? And finally, did anyone watch any news accounts, read any news articles, or see anything in that articles about this case? You did see one?
I did.
Okay, you did not. This was the trick question. So no one observed any of those articles?
No.
Thank you. All right. You may, commence the instructions.
Thank you, Judge. Say we call Allison Harms.
Come on up, take a seat right here. Speak directly into that microphone. They're fairly unidirectional. The clerk will place you in the oath to start off.
Thank you. I solemnly swear affirm that the testimony you shall give in this call shall be the truth, the whole truth, and nothing but yourself with God. I do. Thank you.
All right, thank you. Please state your full name for the record.
My name is Allison Harms.
And what agency do you work for, Ms. Harms?
I work for the Florida Department of Law Enforcement.
Thank you. You may proceed, Mr. Harms.
Good morning, ma'am. How you doing?
Good.
Can you tell us what you do at the Florida Department of Law Enforcement?
I am a senior crime laboratory analyst in the latent print section.
Mind telling us what the latent print section does?
I process items of evidence that are submitted to the lab for the presence of latent prints. I'll then do a comparison of these unknown latent prints to known individuals to either identify or eliminate them.
Now, we know what a latent print is. Do you mind telling the folks what an actual latent print is?
The term latent means hidden, and a latent print is an unintentional or chance impression of the friction-rich skin, which is found on the undersides of your hands and the soles of your feet, left on an object or a surface when it's touched. Because it's hidden, it sometimes needs to be enhanced, and I'll use powders, chemicals, light sources to do this.
What do you usually compare a latent print to?
To an inked print or a known standard. And these are deliberate recordings of the friction-rich skin, and they're made by placing the fingers in a layer of black printer's ink and transferring this to a contrasting color background, such as a standard white fingerprint card.
Do you mind telling us a little bit of your training and background to become a latent print examiner?
So I have a Bachelor of Science from Georgia Southern University that I received in 1996. I also completed a 2-phase training program with the Florida Department of Law Enforcement. The first phase consisted of the academic portion of my training and had written exercises, practicals, comparison exercises. The second phase consisted of supervised casework under the direct supervision of a qualified latent print analyst. I also try to attend a conference or training yearly to keep up with current issues.
Have you, do you annually receive proficiency training in latent print examination?
I do annually take a proficiency test.
Is that just a blind test from an outside source that measures whether or not you're getting things accurate?
Yes,
And you've always passed those tests?
I have.
Thank you, ma'am. Have you ever testified, well, over the course of your career with Fdle, has it been 22, 23 years?
I've worked for Fdle for 25 years now. 23 of those have been in the latent print section.
Over the course of your career, how many actual latent or known fingerprints do you think you've reviewed and compared to one another?
Thousands.
Have you ever testified in court before as an expert in latent print examination?
Yes, I have.
How many times, ma'am?
Approximately 60 times.
If I could bring your attention now to Fdle case number 2020-04-05686. Did you receive some items from the Putnam County Sheriff's Office related to an investigation of a murder to analyze those for fingerprints?
Yes, I did.
When did you receive those items, ma'am?
They were received into the laboratory on August 31st, 2020. And on 9/18/2020.
Now, when those come in, like if there's items that are to be tested for DNA and also fingerprints, where does that go to first?
Everything comes into our evidence intake section, and they start the chain of custody for all the evidence that goes through our laboratory. Things go in an order. So DNA would work evidence before I would throw fingerprint powder on stuff. So everything gets stored in the vault until it's assigned to an analyst and they pick up the evidence.
So certain items that we have or were worked for DNA first, you would have got it after that.
Correct. I would get it after the biology section completed their examinations.
And if I can ask you certain items, did you receive a hammer to look for fingerprints on?
Yes,
Did you receive a knife?
yes,
Did you receive some paper towels?
I did.
And did you receive a cigarette box? Cigarette box?
Yes,
Did you receive a knife sheath that was with a knife?
I did.
May I approach the witness, Judge? You may. I'm going to approach and show you what's in evidence that states 21. If you could take just a look at this, ma'am. I know probably looking at the back will be helpful for you.
Mm-hmm. Yes.
And then looking at the items, can you see numbers and stuff that help you?
Yes, I can.
Okay. Did you, and let's talk about the knife and the hammer and the sheath right here that's in states 21. Did you receive those for processing for fingerprints?
Yes, I did.
Can you tell us if you were able to process those and if there was any results?
So on the hammer and the knife, I start with a visual examination, and then after that, I proceeded to an alternate light source, which using wavelengths will sometimes show me latent prints that are not processed. After that, I process the items with cyanoacrylate ester, or super glue, which when fumed will adhere to fingerprints. After that, I used a dye stain known as Str. And after that, I used a blood reagent called Amido Black that is a protein stain. After all of that, on those two items, I did not find any latent prints of value for comparison on those two items.
What about on the sheath, and can you describe if that's like a different surface or why you would be?
On the sheath and the two fabric placemats, I only did a visual examination because they are fabric, and it is not a surface that's conducive for latent print processing.
So through your, I guess, examination, you didn't see any latent prints of value?
I did not.
Now, if you do have a fabric, if you could see latent prints of value if it were made in blood or in mud or something, that's what you're looking for most of the time?
Correct. So a latent print is, on the undersides of your hands, is the friction ridge skin. And this raised portion of skin is lined with tiny pores. They're constantly exuding perspiration so that when you touch an object or a surface, you're going to leave an outline of these ridges. Also, if your hands are contaminated with some sort of substance, such as blood, paint, or grease, you're going to leave an outline of these ridges as well.
Thank you, ma'am. May I approach the witness again, Judge?
You may.
Ma'am, I'm going to approach and show you what is in evidence of States 23. You can just take a moment, look at the markings, see if it helps you out, and then turn it around for you.
Yes.
You just look at that, look at the items, numbers.
Yes.
Okay. If you could tell the jurors, are these paper towels something you tried to process for prints, or latent prints, I'm sorry?
Yes, these are the paper towels with my initials, and then this is the cigarette pack that I processed for latent prints.
What process did you use on these paper towels?
So on the paper towels, I used a chemical known as ninhydrin. It works with the amino acids found in your perspiration, and I sprayed the items with ninhydrin.
Is that why these paper towels look a little discolored?
It's why they look a little purple. Yes.
And did you find any latent prints of value on the paper towels?
I did not find any latent prints of value on the paper towels.
And on the cigarette box, were you able to process that too?
On the cigarette box, I also processed this item with super glue, black fingerprint powder, and then I also did the ninhydrin on it, and I did not find any latent prints of value on that item either.
Thank you, ma'am. Finally, did you receive a CD that had, I guess, 16 photographs of possible latent prints that were inside the residence when it was processed by the CSI?
Yes, I did.
And can you describe how many, it says 16 photographs, were they all individual 16 photographs or were they repeats?
There were 16 individual photographs, but they were only of 4 different areas.
So I'm going to show you what is in evidence as states. And I'm going to show you states, I believe it's 17C. Maybe. So ignore the P, it's 17C. So if you can look at that, do you recognize this as one of the photographs you may have looked at, ma'am?
Yes.
And let me zoom in. Do you mind stepping down and maybe I can have the witness step down?
Please.
And here is a pointer if it's helpful.
I can just,
Oh, point,
I can
perfect.
just point.
When you received the photograph, were you able to, what's the process you take to see if there's any latent prints of value in there?
So I'm doing a visual exam of all the items when I get it, and I'm looking for the ridge detail that's found in the fingerprints or in latent prints. And I can see right here, there is ridge detail noted right along in this one. And then I can tell by the size and the shape that it's going to be a palm. but it's a right palm. This area right here is this area of your hand, and this area right here is this area of your hand. So it's like this. And this is a right palm. That's the only item on this exhibit that's of value for comparison.
Now, 17C, did you ever receive, and I'm going to show you what's in evidence, it states 27. Can you look at that and see if you received those known fingerprints to actually compare?
Yes, I did.
And who are those fingerprints of, ma'am?
These are finger and palm print standards bearing the name Tate S. Baker.
When you opened up those fingerprints of Tate and Baker, were you able to compare his fingerprints to that palm print left there?
I was.
Did you make any determination or results of that examination?
I identified the palm print located on this, in this photograph, to the palm print standards bearing the name Tate S. Baker.
Do you know which palm print? Was it his right hand?
It was the right palm print.
And the process that you look at is you actually look at the ridge detail and other factors or circumstances in the known fingerprint or palm print, and then you compare it to what you see there?
Yes, to make comparisons, we place the prints side by side, and I'm looking at the individual ridge flow and the individual characteristics in each print to determine if they're in the same relative position and unit relationship to one another. And basically by that, what I mean is that each characteristic must correspond not only in its position in each print, but in its position in relation to all the other characteristics that are in the print.
And your determination was they were a match for Tate and Baker's right palm print?
Correct, yes.
Thank you, ma'am. Ma'am, just a moment, Judge. You may. No further questions, Judge.
Cross-examination?
No question.
All right. Permanent excusal?
Yes, sir.
All right, thank you very much, ma'am. You are permanently excused as witness.
Thank you.
Thank you, ma'am.
Thank you.
Your next witness, State.
State calls Amanda Stratton.
You can take a seat right here, ma'am, and then speak directly into that microphone once you get settled. The clerk will place you on your oath.
Okay.
Do you solemnly swear or affirm that the testimony you shall give in this call should be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
All right, thank you. Please state your full name for the record.
My name is Amanda Stratton. My last name is spelled Stratton.
Thank you. And what agency do you work for?
I work for the Florida Department of Law Enforcement out of Jacksonville, Florida.
Thank you very much. You may proceed, Ms. Dunn.
Thank you.
Thank you. Good morning, Ms. Stratton.
Good morning.
Will you explain to the jurors what you do for the Florida Department of Law Enforcement?
I am a crime laboratory analyst in the biology DNA section in Jacksonville, Florida at the Florida Department of Law Enforcement.
And how long have you been employed with Fdle?
I have been employed with Fdle for almost 9 years.
And have you been in that same discipline of DNA for those 9 years?
Yes, I have.
Did you have any experience in the field prior to your employment at Fdle?
I did. Prior to my employment at Fdle, I was employed as a forensic serologist at a private DNA testing laboratory located in South Florida called DNA Labs International. I was in that position for approximately 3 years before I moved to Jacksonville and assumed the role of crime laboratory analyst at the Fdle.
And what type of educational background or degrees do you hold?
I obtained my Bachelor's of Science in Forensic Science from the University of Central Florida, as well as a minor in chemistry from the University of Central Florida in 2010.
And what type of training did you undergo at Fdle to fulfill your role in the DNA section?
Fdle has a two-part program. In the first phase, it's broken into a series of modules. For each module, I am required to review academic literature, perform laboratory tasks on mock samples, and I have to complete a written assessment at the end of each module. At the end of that first phase, I take an oral board with my peers and my technical leader. The second phase is supervised casework under the direction of a qualified laboratory analyst, and then that is completed with a mock trial.
Can you describe your job duties? What do you do on a daily basis in your role at Fdle?
I examine items of evidence for the possible presence of bodily fluids. I will collect samples from those items of evidence and perform DNA testing on those items. Once I obtain DNA profiles from the items of evidence, I will compare those DNA profiles to DNA profiles from known individuals, and then I report my findings and testify as needed. Part of my job also includes assisting with training or assisting with validations, as well as undergoing continuing education.
Approximately how many items of evidence have you tested for DNA?
I have tested thousands of items in hundreds of cases.
And how do you stay current in your field?
I'm required to undergo continuing education on an annual basis, at least 8 hours, but typically we end up doing usually about a week-long conference every year. And then we also participate in journal article reviews, literature review on a monthly basis.
Is the Florida Department of Law Enforcement lab in Jacksonville accredited?
We are accredited. It is accredited by the American Standards Institute National Accreditation Board. And we have held that our accreditation status since 1990. Being accredited just means that we've demonstrated our ability to adhere to standards set forth by the forensic DNA testing community, including the FBI quality assurance standards. It also confirms that we are in compliance with our own policies and procedures. In order to maintain that accreditation, we have to undergo internal audits every year, external audits every other year, and then reaccreditation audits every 4 years.
You mentioned you've testified before, and that's part of your duties. Do you know how many times you've testified in this area?
I have testified 35 times.
What is contamination and how do you prevent it in your lab?
Contamination is the introduction of, or unintentional introduction of DNA into a sample. We take procedures, quality control procedures, to minimize the possibility of contamination into a sample. Part of those is wearing personal protective equipment, meaning we will use gloves and change them frequently. We are wearing our lab coats and masks and hairnets when we are working with items of evidence. We have to clean our utensils and tools between each item of evidence. And we also will run what's known as a reagent blank in parallel with our samples to monitor for any potential contamination. We have controls set in place throughout the DNA testing process that check for this, and then we evaluate it throughout the entire process.
Do you undergo proficiency training, and how often, if so?
Yes, I am required to undergo proficiency testing twice a year. A proficiency test is a test provided by an external agency. Ours is Collaborative Testing Services. They submit a test to us. I am to treat it like I would any normal case working sample or samples, and my results are sent back to Collaborative Testing Services. They check to make sure that I obtained the correct result.
Have you ever failed one of those proficiency tests?
I have not.
What is chain of custody, and what measures are done at your lab to ensure that?
A chain of custody is something to track the item of evidence throughout the entire case, from the time it's collected to the time the case is completed. As it pertains to Fdle, once an item of evidence is submitted to the laboratory, it is given a unique case number and item number. And that it's a label is placed onto that item, and it keeps that same number throughout the entire testing process. When it's submitted to the laboratory, it's placed into a secure vault, and only a select number of individuals have access to that vault, and they will transfer the items of evidence to me when I'm ready to perform testing on them. When I'm completed with my testing, they can stay in my secure storage locker, and then I can return them back to our evidence section. And all of these transactions are monitored within our laboratory information management system called LIMS.
And can you tell the jurors, explain to them what DNA is.
DNA stands for deoxyribonucleic acid. It is our genetic makeup. It gives us our physical outward appearance, and it also instructs our body on how to function. We get half of our DNA from our mother, half from our father, and no two individuals have the same DNA profile with the exception of identical twins. Now, most of our DNA, though, throughout our body is the same, meaning humans are born with 2 arms and 2 legs and 2 eyes, but there's a very, very small percentage of DNA that is unique to each person with the exception of identical twins, and that is what makes DNA so forensically significant.
What is Str DNA analysis when you talk about that?
STR stands for short tandem repeat. So if you think of your genome as a map, I am specifically interested in 21 locations on that map, on our genome, plus 3 gender determining markers. So I'm looking at 24 total locations on our genome. At each one of those locations, I'm checking to see for a specific pattern of the DNA and how many times that pattern repeats itself back to back to back. We count how many times it repeats itself, and that is known as a DNA type. So I expect to see 2 DNA types at each location, one that comes from your mother and one that comes from your father. So I'm looking at 24 areas and 2 DNA types at each one of those locations.
And what are the steps in the lab that you perform to obtain those results?
There are a series of 4 steps that I have to perform. The first step is called extraction. Essentially, I'm removing the DNA from the material that it's on. Oftentimes, that's a cotton swab. So I will place that sample into a tube with a lid, and we add chemicals and then apply heat. And it's almost similar to the way that you would wash stained laundry. And that stained liquid is isolated and then further purified, and that is my DNA sample that I will take on to the next step called quantitation. So quantitation is where I am measuring how much DNA I have in my sample. This is important for me because I need to know how much I'm working with for the next step, which is called amplification. The third step of amplification is also known as PCR, which stands for polymerase chain reaction. I'm making millions and millions of copies of those specific targeted DNA patterns. And it's done in a way similar to the way that your body naturally replicates DNA. So it makes millions of copies. The final step is called detection. So that sample is placed onto an instrument that detects the DNA fragments, and it generates a graph with a series of peaks and valleys, and that graph is what we call the DNA profile. And then I make my comparisons.
Is it standard procedure to calculate statistics on certain DNA profiles?
Yeah, any type of association that is made to from a known individual DNA profile to DNA from evidence, I have to provide a statistic, and I perform statistics. I give a likelihood ratio. So it is no different than us determining the likelihood of rain outside today if there are gray clouds in the sky. I'm specifically interested in the likelihood of the observed evidence, giving 2 alternating arguments.
And do you, does computing that statistic also include the use of a database?
It does. I use a database called the US 29 autosomal STR loci for the US population, and it contains 1,035 samples that were provided to the NIST laboratory, and they perform DNA testing on those samples. These are liquid blood samples and buccal swabs or cheek swabs from known individuals who are unrelated, and their ethnicities are self-identified. So they perform DNA testing on these samples to determine how frequent we expect to see each DNA type in the general population.
Ms. Stratton, did you examine evidence in the case of the 2 homicide victims, Robert and Tate Baker?
Yes, I did.
Did you receive any buccal swabs or buccal swabs from known individuals to compare to any profiles you may develop through evidence?
I did.
And do you recall who you received samples from?
I received buccal swabs from, buccal swabs from Robert Baker, buccal swabs from Tate Baker, buccal swabs from Cynthia Guinan, buccal swabs from Mark Wilson Jr., buccal swabs from Sarah Benson, and buccal swabs from Chad Baker.
And you mentioned earlier, I believe in your example of how you process evidence, the example you used was from a Q-tip. Would that have been that process that you did with those items of evidence to develop a profile?
Yes, a buccal swab is a swabbing from the inside of the cheek, and it's used to develop a DNA profile for that individual to be used for comparison to DNA profiles from items of evidence, and I did perform all of those steps on these buccal swabs.
And did you obtain complete profiles for all of those known individuals?
I did.
Your Honor, may I approach?
You may.
Ms. Stratton, I'm going to approach you with what's already been admitted into evidence as states 34, and just ask if you recognize this particular buccal swab and who it was stated to be from.
I recognize this item. This is our Fdle label here with the yellow label. These are my markings on this item, and this is my seal along the bottom that I placed on the item after I completed my examination. These are buccal swabs from Mark Wilson Jr.
Thank you. I want to ask you now about specific items of evidence that you received in this case to analyze. Did you receive a hammer identified as Fdle item 1.1?
I did.
And a knife and sheath that your agency labeled as 1.2?
Yes.
2 different placemats that your agency labeled 1.3 and 1.4?
Yes, I did.
Your Honor, may I approach?
You may.
Stratton, I'm going to show you what's already been introduced into evidence as states 21. I'll show you the front and then the packaging.
Okay. Okay.
Are the items I just went through with you, are these the items that you received and examined for DNA evidence in this case?
Yes, they are.
And there's several markings and things on there. Do you do that throughout your process?
Yes. All of these circles that you see in black, those are on the placemats. Those are my markings where I perform testing. And then any markings on the weapons, I also would mark where I collected samples from or performed testing on these items. I also included the evidence tag here. All of these were submitted in one package, and so I separated those out. This was the package they were submitted in. And so I individually gave them the item numbers 1.1, 1.2, 1.3, 1.4.
I'm going to leave this right here for now, and I may come up and ask you about them. I want to talk to you first about the hammer. In this case, Fdle item 1.1, did you test that item for the presence of DNA?
I did. I performed serology testing also, which is testing for the possible presence of a bodily fluid. So I performed testing for the possible presence of blood on this item, and it did give chemical indications for the presence of blood.
And so what did you do when you located those items of blood?
I collected 3 samples from the hammer, item 1.1. One was stain A, which was located on the underside of the hammerhead. One I named stain B, which was located on the dark blue textured area of the handle. And then lastly, I collected a handler sample where I swabbed the handle of the hammer, avoiding any possible red-brown staining for possible touch DNA.
And what were your initial results as to that item?
The DNA results from items 1.1 stain A, 1.1 stain B, and 1.1 handler all demonstrated the presence of mixtures of 2 individuals with at least 1 male individual.
Were you able to compare your results to the known buccal swabs and profiles you obtained and make any determinations?
I did. I first compared Tate and Baker to these DNA mixtures. Tate and Baker is included as a possible contributor to these mixed DNA profiles. The observed mixed DNA profiles are greater than 700 billion times more likely to occur if it originated from Tate and Baker in 1 unrelated individual, rather than if it originated from 2 unrelated individuals. The next comparison that I made was Robert Baker to these mixtures, and I determined that Robert Baker is excluded as a contributor to these mixed DNA profiles.
And did you move on and continue to compare, since you had Tate plus 1 unknown, did you continue to compare to the other DNA profiles you had?
I did. Next, I compared the DNA profile from Mark Wilson Jr. And the comparison of the profile from Mark Wilson Jr. to the mixture obtained from item 1.1 stain A failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contributions of Mark Wilson Jr. to this item.
So what is no determination is one of the terms you will report out. What is that?
Correct. So no determination, I also call inconclusive. It simply means that there is not enough data in my sample in order to support an exclusion or an inclusion into that mixture. So no determination can be made regarding that contribution.
Did you make a determination as to Cindy or Cynthia Guinan?
Yes. Cynthia Guinan is excluded as a contributor to the mixed DNA profile obtained from item 1.1 stain A. And then yes, I also compared Chad Baker. Chad Baker, comparison of the profile from Chad Baker to item 1.1 stain A failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of the DNA profile from Chad Baker to that item.
Okay, and then Sarah Benson as to stain A.
Sarah Benson is excluded as a contributor to the mixed DNA profile from 1.1 stain A.
Okay. So essentially, does that mean, so the jurors understand, as to Cynthia Guinan and Sarah Benson on the hammer, excluded, absolutely, they are not, they don't match that DNA profile at all?
That's correct.
Okay. And then you just simply don't have enough information to make a decision as to Chad Baker and Mark Wilson?
Correct. And this is for stain A on item 1.1.
And then stain B were Cynthia Guinan, Sarah Benson, and Chad Baker all excluded.
Yes, that is correct.
And what about Mark Wilson Jr.?
The comparison of the profile from Mark Wilson Jr. to item 1.1 stain B failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of Mark Wilson Jr. to item 1.1 stain B.
Okay. And now for the handler sample, which was the area on the handle avoiding the red brown staining, correct?
Yes.
Again, Cindy, Sarah Benson, and Chad Baker were excluded from that sample, is that right?
That's correct.
And no determination as to Mark Wilson Jr., is that right?
Yes, that is correct.
Okay. I want to move on to 1.2, the knife and the sheath of the knife. Did you go through similar testing process for that item of evidence, 1.2?
I did. I performed the presumptive blood testing on this item. And this item, 1.2, the knife with the sheath, gave chemical indications for the presence of blood.
And did you take samples of stains in other areas of that item?
I did.
You had a stain on the knife. Can you tell the jurors where stain A was located and what your results were for that stain?
Stain A was located at on the blade near the base handle area of the knife. And I obtained a complete DNA profile consistent with a male individual from item 1.2, stain A.
And who was that individual?
I compared this DNA profile to the DNA profile from Tate and Baker, and this DNA profile matches the DNA profile from Tate and Baker. The observed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate and Baker than from an unrelated individual. Other limited data was observed in a sample, which is not interpretable and may suggest the possibility of an additional contributor to that sample.
And what about stain B?
Stain B was located on the handle near the blade, and
Go ahead.
the DNA results obtained from item 1.2, stain B, demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Tate and Baker is included as a possible contributor to this mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Tate and Baker and 1 unrelated individual than from 2 unrelated individuals. Robert Baker is included as a possible contributor to the mixed DNA profile from item 1.2, stain B. The observed mixed DNA profile is approximately 19,000 times more likely to occur if the sample originated from Robert Baker and one unrelated individual than from 2 unrelated individuals.
Okay. And all other profiles you compared were excluded for that stain B. Is that correct?
Yes, that is correct.
Okay. So you have Tate and Robert on that particular stain. The statistics are obviously different for the 2 boys. Can you kind of describe to the jurors why that may happen or the various reasons why that can happen?
Sure. For this particular sample, 1 donor in this mixture of 2 donors was contributing significantly more higher amounts of DNA into that sample than the other. So the more information for that donor to that sample, the higher that likelihood ratio is expected to be. The less information for any donor, the smaller that likelihood ratio is I would expect to be. So in this particular sample, 1 donor is just contributing more DNA than the other.
And stain C, you describe your results for stain C and where it was on the knife.
Stain C was located on the sheath near the opening. And the DNA result from item 1.2, stain C, demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Tate and Baker is included as a possible contributor to this mixed DNA profile. and the observed mixed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate and Baker and one unrelated individual than from two unrelated individuals.
Robert Baker, Sarah Benson, and Cynthia Guinan, you reported that were excluded from that stain, is that correct?
Robert Baker is excluded, as well as Cynthia Guinan and Sarah Benson, yes.
And what about Mark Wilson Jr. and Chad Baker? What determination, if any, we would make?
Comparison of the profiles from Mark Wilson Jr. and Chad Baker to the mixture obtained from item 1.2, stain C, failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contributions of Mark Wilson Jr. And Chad Baker to this item.
And you had a stain D. Where was that located, and what were the results?
Stain D was located near the end, on the sheath near the end of the handle. The DNA results obtained from item 1.2, stain D, demonstrated the presence of a mixture, and due to the limited nature of this mixed DNA result, this data is not interpretable.
So you just weren't able, you don't have enough information to make any comparisons?
That's correct.
Okay. Then you have a handler sample taken from the knife and sheath. Where was that taken? And then we'll talk about the results.
I collected a handler sample from the narrow top and bottom edges of the handle, as well as the exterior sheath, avoiding any red-brown staining.
Okay. And were you able to make any identifications or comparisons?
The DNA results obtained from item 1.2 handler demonstrated the presence of a mixture consistent with two donors, including at least one male contributor. Tate and Baker is included as a possible contributor to this mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate and Baker and one unrelated individual than if it originated from two unrelated individuals.
And as to Mark Wilson Jr. for this item?
Mark Wilson Jr. is included as a possible contributor to the mixed DNA profile obtained from item 1.2 handler. The observed mixed DNA profile is approximately 55,000 times more likely to occur if the sample originated from Mark Wilson Jr. and one unrelated individual than from two unrelated individuals.
Okay. Now you already explained one reason why, or the reason why statistics could be different, the different amount of data and the different amount of DNA present. How would the type of DNA that you're analyzing play into that, meaning a bodily fluid versus a touch DNA sample?
I typically expect to see a robust DNA profile from bodily fluids as long as they are not degraded and as long as they are preserved correctly. Touch DNA is often a lot more variable, and the results can be very limited oftentimes compared to bodily fluids, which usually are a rich source of DNA.
Okay. So as this is the knife in this case, if Mark Wilson's handling of that knife was touch and Tate and Baker's blood is on that knife, do those DNA results, is that consistent with that scenario?
It's possible, yes.
And as to Robert Baker, Cynthia, Sarah Benson, and Chad Baker, they're all excluded from that handler sample, is that correct?
Yes, that's correct.
Now I want to go over the placemat that you labeled 1.3. What were your results as to that placemat, and how did you go about looking at that if it was different from the other items?
So I examined both sides of the placemat. So I labeled one side A and one side B for each placemat. I also performed possible blood testing, and item 1.3 gave chemical indications for the presence of blood.
Okay. And what were your results? Did you take samples from any stains on that item?
I did. I collected a sample from stain A, which was located in the center of side A. And the DNA results from item 1.3 stain A demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor.
What were your results after you compared them to your standard DNA profile? Or no DNA profile?
Tate and Baker is included as a possible contributor to this mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Tate and Baker and 1 unrelated individual than from 2 unrelated individuals. Robert Baker is excluded as a contributor to this mixed DNA profile.
And what about Mark Wilson?
Mark Wilson Jr. is included as a possible contributor to the mixed DNA profile obtained from item 1.3 stain A. And the observed mixed DNA profile is approximately 1.9 thousand times more likely to occur if the sample originated from Mark Wilson Jr. and 1 unrelated individual than from 2 unrelated individuals.
And on stain A, Cynthia, Sarah, and Chad were excluded as contributors, is that right?
That's correct.
Okay. Your may I approach?
You may.
Okay. And I just want to make sure jurors know before we move on. So 1.3, can you just point to on which stain that is? When you say stain A, where you just identified Tatum and the defendant.
This is item 1.3 here, and this is stain A, where I've marked it right in the center of the placemat.
Okay. And then back to the other item we just covered, which was 1.2, the knife in the sheath, and that handler sample where you identified Tatum and the defendant. Can you just show the jurors where you would have taken that from? You described it, but I'm sorry, I'm going back on.
That's okay. I'm just going to read what my notes say.
Yeah, 1.2, handler.
So the narrow top and bottom edges of the handle of the knife, meaning up here, because I needed to preserve any possible smooth surfaces for any latent print testing. And then I also swabbed the exterior of the sheath, avoiding any red-brown staining.
Thank you. Okay. All right, and then that other place mat. We're still on 1.3. On that same place mat where you just pointed out stain A, you do a handler sample as well. Tell the jurors how you did that on a placemat.
I collected a general swabbing of the placemat, avoiding any red-brown staining. And so I swabbed both sides with one swab.
And did you have a DNA result?
The DNA results from item 1.3 handler demonstrated the presence of a mixture consistent with 4 donors, including at least 1 male contributor. Tate and Baker is included as a possible contributor to the mixed DNA profile. And the observed mixed DNA profile is approximately 1.1 million times more likely to occur if the sample originated from Tate and Baker and 3 unrelated individuals than from 4 unrelated individuals. Robert Baker is included as a possible contributor to the mixed DNA profile. And the observed mixed DNA profile is approximately 96,000 times more likely to occur if the sample originated from Robert Baker and 3 unrelated individuals than from 4 unrelated individuals.
And then comparing to Mark Wilson.
Mark Wilson Jr. is included as a possible contributor to the mixed DNA profile obtained from item 1.3 handler. The observed mixed DNA profile is approximately 280 million times more likely to occur if the sample originated from Mark Wilson Jr. and 3 unrelated individuals than from 4 unrelated individuals.
And so when you look at the statistics for that item, Mark Wilson had the greater, and I might be using the wrong word, so statistical significance at 280 versus Tate at 1.1, or just explain that.
280 million times it's a greater likelihood ratio than 1.1 million. And I can't remember what the other one was, excuse me, 96,000 times. It just means that there's more information for that particular contributor in that mixture in order for me to obtain that greater likelihood.
And one reason for that could be that there was more DNA present for Mark Wilson than the other 2 that were identified, is that correct?
Yes.
And I believe Cynthia, Sarah, and Chad were no determination as to their being identified with that mixture.
Correct. Comparison of the profiles from Cynthia Guinan, Sarah Benson, and Chad Baker to the mixture obtained from item 1.3 handler failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of these individuals to that item.
Okay. May I approach again, Joanne? I'm going to move on to 1.4 and just point out where this stain is before we talk about it. We're going to talk about stain A first in 1.4. Just show the jurors where that is.
Okay, this is 1.4 side A, and this is stain A here. And then as you can see on the back of this placemat, which I labeled as side B, I collected a sample from stain B.
And tell the jurors what your results were first as to stain A.
I did perform presumptive blood testing on this item, and it did give chemical indications for the presence of blood. And the DNA results from item 1.4 stain A, which was located in the middle of that side A, demonstrated the presence of a mixture consistent with 4 donors, including at least 1 male contributor. The Tate Baker is included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate Baker and 3 unrelated individuals than if it originated from 4 unrelated individuals. Comparison of the profile from Robert Baker to this item, to this mixture, failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of Robert Baker to that sample. Mark Wilson Jr. is included as a possible contributor to the mixed DNA profile obtained from item 1.4 stain A. And the observed mixed DNA profile is approximately 220 million times more likely to occur if the sample originated from Mark Wilson Jr. and 3 unrelated individuals than from 4 unrelated individuals.
And then again, on that item, Cynthia Guinan, Sarah Baker, and Chad Baker were similar to Robert in that no determination was able to be made, correct?
Comparison of the profiles from Cynthia Guinan, Sarah Benson, and Chad Baker to the mixture obtained from item 1.4 stain A failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of those individuals to that sample.
And so now the stain B that you took from the back of 1.4, did you obtain a mixture DNA profile from that stain?
I did. The DNA results from item 1.4, stain B, demonstrated the presence of a mixture consistent with 4 donors, including at least 1 male contributor. Tate and Baker is included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate and Baker and 3 unrelated individuals than if it originated from 4 unrelated individuals. Robert Baker is included as a possible contributor to this mixed DNA profile from item 1.4, stain B. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robert Baker and 3 unrelated individuals than if it originated from 4 unrelated individuals.
So Tate and Robert are 2 of your potential at least 4 donors. Did you look at Mark Wilson for this?
Mark Wilson Jr. is included as a possible contributor to the mixed DNA profile obtained from item 1.4, stain B. The observed mixed DNA profile is approximately 1.3 million times more likely to occur if the sample originated from Mark Wilson Jr. and 3 unrelated individuals than if it originated from 4 unrelated individuals.
And then Cynthia Guinan.
Cynthia Guinan is included as a possible contributor to the mixed DNA profile from item 1.4, stain B. And the observed mixed DNA profile is approximately 22,000 times more likely to occur if the sample originated from Cynthia Guinan and 3 unrelated individuals than if it originated from 4 unrelated individuals.
And Sarah Benson and Chad Baker, it was a no determination due to insufficient amount of information, correct?
That's correct.
Okay. Now, may I approach Jonas?
You may.
Ms. Stratton, I'm going to show you states 23 that's been admitted into evidence. And again, I'll show you the front and then the packaging and let me know if you recognize this.
I do.
And what do you recognize it as?
This is Fdle item 2. Paper towels with red-brown staining.
And this is an item, oh, go ahead.
Also a cigarette box.
Okay. And that tag there in the middle, that would have been placed by yourself?
That's correct.
Okay.
And I inventoried the number of paper towels once I opened them up, and I labeled them A through F, and then I labeled the cigarette boxes G.
Okay. And when we talk about these items, tell the jurors how you went about processing these, if it was different or similar to the hammer knife.
The paper towels in item 2 gave chemical indications for the presence of blood. I collected a sample from each paper towel and called each sample 2A, 2F, I'm sorry, 2A, 2B, all the way through 2F.
So when you did that, like let's say paper towel that you labeled A, you just took one swab from the staining on paper towel A and called that A, is that right?
I collected a cutting from the stain.
Okay.
And that's what I performed the DNA testing on for each of these stains.
Okay, so that's a little bit different than how you process those items.
So for the placemats, I took cuttings of the stains. And then for the hammer and the knife and the knife sheath, I have to swab those stains because I can't cut through that type of material. But if it's material that I can cut through and fit into a tube, then I would typically take a cutting from that type of staining.
And your results as to all of them, A, B, C, D, E, and F, resulted in Tate and Baker being included in those, correct?
Stains A, B, D, E, and F. I obtained the same complete DNA profile consistent with the male individual, and this DNA profile matches the DNA profile from Tate and Baker. And the observed DNA profile is greater than 700 billion times more likely to occur if it originated from Tate and Baker than if it originated from an unknown, unrelated individual. For stain C, other limited data was observed in the sample, which may indicate the possible presence of an additional contributor to this DNA profile.
Okay, so A, B, D, E, and F, was that DNA profile with one person?
Correct. And for stain C, Tate and Baker, I obtained a complete DNA profile as well for that, and that DNA profile matched the DNA profile from Tate and Baker.
There was just possible information that there could be another contributor in C.
That's correct.
But for A, B, D, E, and F, different than what we've been talking about with the other items that were kind of all mixtures, this is one individual.
Yes, that's correct.
And that's in the staining of those items, correct?
Yes, that's correct.
Okay. And then you took a sample from those items and called it handler. Again, just describe to the jury how you did that in those evidence items.
I collected a general swabbing of the paper towels A through E, as well as the cigarette box, avoiding any red-brown staining. I did not collect any a handler sample from paper towel F because it was heavily saturated. So only paper towels A through E and the cigarette box were swabbed for possible handler with one swab.
And what was your results as to the handler for those items?
The DNA results from item 2 handler demonstrated the presence of a mixture consistent with 2 donors, including at least 1 male contributor. Tate and Baker is included as a possible contributor to this mixed DNA profile. And the observed mixed DNA profile is approximately 290,000 times more likely to occur if the sample originated from Tate and Baker and 1 unrelated individual than from 2 unrelated individuals. Robert Baker is excluded as a contributor to this mixed DNA profile. Comparison of the profiles from Cynthia Guinan, Mark Wilson Jr., and Chad Baker to the mixture obtained from item 2 handler failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of Cynthia Guinan, Mark Wilson Jr., and Chad Baker to item 1.2 handler. Sarah Benson is excluded as a contributor to the mixed DNA profile from item 2 handler. Excuse me, I think I may have said item 1.2 handler before, but I meant 2.
Yes, ma'am. Okay. And lastly, Your Honor, may I approach you?
Okay.
I'm going to show you what's been marked and entered as case 31. Again, take a look at this item on the front in your packaging.
Yes. Okay.
And do you recognize this item?
I do. These are my markings here in the hood, and I collected multiple samples from this item.
Okay. And I'll just point out now, because it probably won't show the whole time, but there is a cutout here to show what? What was
This
that?
is stain D that I collected for testing.
Okay. Just point out if you know where the rest of them are.
1 second. Stain A is on the wearer's right sleeve and wrist, so over here. Sorry, over here. Stain B is the wearer's left sleeve and wrist. Stain C is the wearer's front abdominal area. And stain D was the back center.
And you have those marked here as well.
A, B, C, and then D is on the back.
All right, start with A. If you were able to obtain any results for stain A.
I performed presumptive blood testing on this item, and it gave chemical indications for the presence of blood. The DNA results obtained from 11 stain A, which was from the wearer's right sleeve and wrist area, demonstrated the presence of a mixture consistent with 3 donors, including at least 1 male individual. Mark Wilson Jr. is included as a possible contributor to this mixed DNA profile. And the observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Mark Wilson Jr. and 2 unrelated individuals than from 3 unrelated individuals.
And as for the other profiles, I believe Chad Baker is excluded, is that correct?
Chad Baker is excluded as a contributor to the mixed DNA profile from item 11, stain A.
And then no determination as to the other standard known profiles you have.
Correct. Comparison of the profiles from Robert Baker, Tate Baker, Cynthia Guinan, and Sarah Benson to the mixture obtained from item 11, stain A failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contributions of Robert Baker, Tate Baker, Cynthia Guinan, and Sarah Benson to this item.
And stain B, remind the jurors where that one was taken from.
Stain B was from the wearer's left sleeve wrist area.
Okay, and then I believe the results for that and wearer are the same, so we'll talk about them at the same time. Where did you take a wearer sample from?
I collected a wearer swab or sample by swabbing the neckline and both underarm, interior underarm areas for possible wearer DNA. And the DNA results obtained from item 11 stain B and item 11 wearer demonstrated the presence of mixtures. Due to the complexity of these mixtures, this data is not interpretable.
And stain C, remind the jurors where that stain is first, and then tell us about your results.
Stain C was collected from the wearer's front abdominal area. The DNA results obtained from item 11 stain C demonstrated the presence of a mixture consistent with 4 donors, including at least 1 male contributor. Robert Baker is included as a possible contributor to the mixed DNA profile. The observed mixed DNA profile is approximately 11 million times more likely to occur if it originated from Robert Baker and 3 unrelated individuals than from 4 unrelated individuals. Tate Baker is included as a possible contributor to the mixed DNA profile from item 11, stain C. The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Tate Baker and 3 unrelated individuals than from 4 unrelated individuals.
And we've heard that a lot through your testimony today with Tate. The statistics are often 700 billion. Is that the highest statistic you can report out, or does that just happen to be what Tate's was throughout this case?
You frequently heard me say 700 billion. We use that number as for ease of reporting so that we can kind of group our reporting segments together if we're making multiple comparisons. But the actual likelihood ratio could be significantly larger than 700 billion. It's approximately 100 times the population of the Earth. However, the population of the Earth is irrelevant to the statistic that I'm providing.
You just essentially stop calculating it. It could be higher than that, but it's at least 700 billion.
I do have an actual estimated likelihood ratio that I can always refer to in my statistics report.
And then as to stain C, so this is the one on the front abdominal area of this sweatshirt. Tate and Robert have been identified, I believe, as to all the remaining profiles, no determination.
Comparison of the profiles from Cynthia Guinan, Mark Wilson Jr., Sarah Benson, and Chad Baker to the mixture obtained from item 11 stain C failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contributions of Cynthia Guinan, Mark Wilson Jr., Sarah Benson, and Chad Baker to this item.
And now stain D, which is the one we see on the back of the hoodie. Did you obtain a mixture?
The DNA results obtained from item 11, stain D, demonstrated the presence of a mixture consistent with 3 donors, including at least 1 male contributor. Robert Baker is included as a possible contributor to the mixed DNA profile.
And the statistics?
The observed mixed DNA profile is greater than 700 billion times more likely to occur if the sample originated from Robert Baker and 2 unrelated individuals than from 3 unrelated individuals.
And no determination on the remaining profiles, is that correct?
Correct. Comparison of the profiles from Tate and Baker, Cynthia Guinan, Mark Wilson Jr., Sarah Benson, and Chad Baker to the mixture obtained from item 11, stain D, failed to demonstrate sufficient statistical support for inclusion or exclusion. Therefore, no determination can be made regarding the contribution of Tate and Baker, Cynthia Guinan, Mark Wilson Jr., Sarah Benson, and Chad Baker to this sample.
Okay. Here, may I approach one last time?
You may.
Okay. I just want to take it, summarize that, because that's obviously a lot of information. Stain A is on the sleeve closest to you, is that right?
Yes, that's correct.
Okay. And that was the one in which, I know I'm gonna, Mark Wilson was identified with the statistics of 700 billion as the likelihood.
Mark Wilson Jr. possible contributor to the mixed DNA profile from stain A, and the likelihood ratio was greater than 700 billion times.
Right. And then stain C is here, and you even see your cutting right here, correct?
Yes.
And that's the one we just discussed with Tate and Robert, correct?
Robert Baker and Tate and Baker are included in stain C.
And then the last one that you identified anyone with a likelihood ratio is D, and that was Robert. Is that correct?
Robert Baker is included in stain D.
No further questions, Your Honor?
Cross-examination.
May I approach the witness?
You may.
I'm approaching the witness with states 21. So this placemat here is item 1.4, correct?
Yes, that's
Okay.
correct.
And this is stain B on 1.4, correct?
Yes.
And that was the stain that had Cindy Guinan's DNA profile that was included?
Yes, that's correct.
Can I have a moment?
You may.
No further questions.
Can you read the record?
No, Your Honor.
Affirmative refusal?
Yes.
All right, thank you very much for your affirmative excuse.
Thank you.
Your Honor, it's time to state rest.
All right, thank you. This is a good time for a break. So ladies and members of the jury, please step into the jury room. Please don't discuss among yourselves the case. This one may last us. We have some things we have to talk about, planning, scheduling, things like that. So this may take a little bit longer, but anticipate at least 15 to 20 minutes. Thank you.
All rise, jurors exit the courtroom, please.
All right, thank you. take a recess for about 5 to 10 minutes before we come back in. I know we've got some motions to deal with, so back in about 5 to 10 minutes.
Three, two. Right now, the defense is calling its witnesses to the stand. Earlier this morning, we heard from two Florida Department of Law Enforcement investigators. They specialize in lab analysis, and they talked about the blood samples on both the murder weapons, the sweatshirt, and some table placemats as well. They say that they found both the victim's blood on these samples as well as the alleged killer, Mark Wilson. Now, they rested around a little bit before 10 a.m. this morning, and again, we're hearing from the defense witnesses right now. We'll continue to keep you updated in this ongoing murder trial. We are now on day 3. We will have an update for you on Action News Jax at 5. For local coverage, you can count on in Palatka, Megan Moriarty, Action News Jax.
Hopefully it doesn't mess you up.
Is that for the
News.
news?
I think it sounds
So those are just interesting what they look like. It's a transmitter.
Yeah.
Really interesting, so it goes right to the camera. I won't mess with that.
Can I ask a question about your keyboard thing? Is that like shorthand type
Well,
stuff?
it's actually, unlike shorthand, you have symbols. These are actually letters. You can just look at this as extreme texting.
Do you have any specific deficiencies that you want to point out?
Not at this one, Your Honor, but I will at the secondary.
State?
Judge, we would just, obviously the court's been listening to the entirety of all the testimony. It's clear that there's, in light most favorable to the state, that the evidence establishes premeditation and on both children, and also in the light most favorable to the state, the evidence clearly establishes a burglary under the two different theories. One, a forcible felony is committed, and also upon being asked, allowed to enter, an offense is committed that's violent upon the individual who resides in that house.
Anything else from the defense?
No, Your Honor.
All right. Court concurs in the light most favorable to the state. There is sufficient evidence from which a jury could conclude that each of the 4 counts as stated in the indictment could be proven sufficiently. So I'm going to deny the motion for judgment of acquittal. Okay, Ms. Peoples, have you had a conversation with your client about whether he... Well, first off, tell me how many witnesses you anticipate to call.
I'll defer to
Mr. Smith?
We won't be calling any witnesses this morning.
Okay. So that also means that Mr. Wilson is not going to be testifying on behalf, correct?
That's correct, Your Honor.
All right, Mr. Wilson, I placed you under oath the other day, but I'll go ahead and do it again. If you would, raise your right hand. Do you swear or affirm that the evidence you're about to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You do have a constitutional right to remain silent, and counsel has indicated that you anticipate following that by not putting on any evidence either from yourself or from anyone else. I will be instructing the jury that the fact that you don't testify is not to be considered by them in deliberations. You can testify if you want to. That is a critical decision. And if you do testify, your testimony will be considered like the testimony of all other witnesses. If you do testify, the state will be allowed to cross-examine you. They will be allowed to ask you if you've had any felonies in your past and how many times you've been convicted of a felony. Understanding that you can, if you and the state agree as to how many felonies you were having in your past, the state would not be able to ask about the nature of those prior convictions. The right to remain silent belongs to you. It doesn't belong to anyone else. It's not your attorney's right, it's your right. Have you discussed all of this with your attorney?
Yes, sir.
Do you need any more time to discuss this with your team?
No, sir.
And is it your understanding then that you do not want to testify? Is that correct?
Yes, sir.
All right. Are you under the influence today of alcohol, drugs, medication, or being threatened in any way to make this decision?
No, sir.
Are you being treated for any mental health conditions that may tend to impair your decision-making here today?
No, sir.
So this is your own choice, is that correct?
Yes, sir.
Has the defense has also indicated that they're not planning on putting on any other witnesses. Have you and your lawyers discussed that particular strategy?
Yes, sir.
And are you in agreement with them?
Yes, sir.
Have you discussed any witnesses that you may want to have called with them? And have you given them a list of those witnesses?
No, sir.
All right, so you don't have any witnesses that you want called, is that correct? Is there anything else you would want to bring to my attention before we proceed forward?
Yes, sir.
And you remain satisfied with your attorney's services, correct?
Yes, sir.
Has anybody told you how to answer these questions here this morning?
No, sir.
All right, so I'll accept those representations as being freely and intelligently made. And defense is going to be resting them as well. I'll allow you to do that in front of the jury as well. But will it be any other motions? You said you may have a follow-on motion, Ms. Peoples?
Yes, Your Honor, defense would have a second J argument.
Okay, go ahead.
You may proceed now.
Yes.
Your Honor, defense moves for the second judgment of acquittal. And specifically, I'll start off with counts 1 and 2 for first-degree murder. That the evidence before the court, defense would argue, is lacking in substantial and competent evidence. Though there was testimony, not just of the death and the nature of the death, there is an issue regarding the premeditation. The testimony that the court has received has been unequivocal and consistent that there was no plan or pre-planning of this homicide of these two boys. That on first reflection, the mother testified it was yesterday regarding the statements from Mr. Wilson. And then the state presented the recorded statement of Mr. Wilson. And within his recorded statement, there is a large number of I don't remembers and I don't know. So specific to that element of premeditation, Your Honor, and yes, the state would argue that it only takes a moment. But what the court has is drug use and 3 days of lack of sleep and an admission to a homicide, but not premeditation for that homicide. So for those reasons, Your Honor, defense would argue that his statement is in support of a conviction of a lesser, and that would be second-degree murder, but that there is lacking substantial competent evidence to the premeditation factor. To prove the phrase mind, that an act demonstrates a phrase mind for the purpose of second-degree murder, the state must prove it was done from ill will, hatred, spite, or evil intent, and that's what we had at this juncture. Defense again is arguing that it's more of an impulsive overreaction is what the testimony is before the court regarding the actions of Mr. Wilson. Overreaction in terms of efforts to protect his daughter, protect Cindy, and that's what the testimony is. And one more time. That the expressed testimony is more in support of malice and a state of mind of ill will and spite. Again, because what the testimony is these actions were taken in effort to protect his daughter from what he believed at the time was a sexual assault by these two boys. So, Your Honor, again, just looking specifically at the premeditation element, knowing that the time regarding that is short, the testimony and the evidence before the court, with all those reasonable inferences in the law drawn in favor of the state, defense would argue that there is a lack of competent and substantial evidence on that portion of the elements of count 1 and count 2 to the premeditation. For that reason, defense would argue that that count should be reduced and sent to the jury as 2 counts of second degree.
Anything else on that? Any other counts that you're?
I have arguments on count 3 and 4.
You have?
I have arguments on count 3 and 4.
I'm sorry.
I do have arguments on count 3.
Okay, let's hear all of them now.
Okay. So looking to the burglary charge, defense would also argue here that Mr. Wilson had free access to the property, that he had been living in the home for a substantial period of time, or equal time, I should say, as the homeowners, that his, the doors were left unlocked for the purposes of him to freely enter and remain, and that I do understand that Florida case law and Florida statutes have changed from the common law meaning of burglary, and that the legislature clearly wants to remain in the theory of burglary. But here the test what the conduct or the actual meaning of the language is intended to cover. The statute and jury instructions will contemplate formation of the intent after the entry. And in this specific case, Your Honor, it is proof to support that the charge scenario by Mark Wilson in terms of remaining therein after the consensual entry, forming the intent to batter and ultimately murder these boys. And since you're still looking at the time element regarding the remaining in the burglary is analogous to the time element in the premeditation murder. So we would argue that what is before the court is sufficient for a trespass and a homicide charge, but not for a burglary charge, based on the evidence that is on before the court in this case.
What is the physical limit of the property for the purposes of burglary? Does it require a specific entry into the main house, or is it that you were allowed within the entire property?
Right, and this is, I see where the court's going, but first, in terms of what we have, and there were some maps that were provided or diagrams of the home, that this was one structure with an exterior fence and then another fence that included the areas that Wilson, his girlfriend Cindy, and his daughter were in outside structures that were all connected to the main house that they're all freely accessing. The great distinction would be, for an example, a store, and I'll just pick on Walmart, where there's clear signs indicating that this is an employee-only section. So even though the store may be open for 24 hours and everyone has free access to the store, that portion of the store that's marked off employees only, the individuals that are inside the store can't access that area, break into that area, leave the doors unlocked, and then take things from there, commit a battery in there, or commit a theft in there. That would be a burglary. We don't have that specific distinction in this case. The testimony was that the doors were always left unlocked, meaning those two exterior doors for Wilson and Cindy and their young child, Tate, who was around 14 months at the time, could easily come and go from those doors. We don't have an issue, for example, where they had to cross the street. This is all one property together. So even though the doors are open and they are passing through outside, it's not a marketed separate structure in the same sense that you would have for a bank or a Walmart that's directing that you cannot go past this area.
Let me make sure I understand that your argument then, because as I understood your argument, it was that since he was allowed to come and go, there's no proof that he formed his intent after being allowed in and while remaining there.
That was, yes, Your Honor,
Okay.
I added.
So if that's the theory, my understanding of burglary, particularly where it talks about the building or the property, it includes the entire property, such as this one where it's been enclosed by a fence. It would include the entire property, including any and all outbuildings. So yes, he was on the property when he formed that intent, but I think, isn't that exactly what the legislature was going at with the remaining in statute? I don't think changing buildings matters, I guess is the point. If that's your theory, and that's where I'm confused.
Yes, Your Honor, so what we're contesting is the language and the evidence that's been presented in this specific case.
Okay, all right. And that goes for 3 and 4?
Yes, Your Honor.
Okay, was there anything else on 3 or 4?
No, other than, and I would add that to the felony murder allegations in count 1 and 2. So I did start off with 3 and 4, but it would also, that same argument would extend to count 3.
Okay, Mr. Lewis?
Thank you, Judge. And of course, the state does respectfully disagree with the defense's argument. First off, first and foremost, we don't think it takes moments to form premeditation. It's seconds, Judge. So I won't agree that it takes moments. Secondly, the defendant's statements themselves are not the evidence that the jury only relies on in this case, Judge. It's the circumstances of the crime, and the defense seems to want to ignore those. The circumstances of arming himself with 2 different weapons, entering into a location where there is a distance he has to go to the first victim, repeatedly striking the victim with a hammer, and then slitting the throat and stabbing him multiple times. And then after doing that to the first victim, he proceeds to the second victim and does the same exact crime, Judge. In fact, he hits that victim a minimum of 6 times in the head, and he uses, at least I think Dr. Fulcher said, 12 to 13 different slashes or stab wounds on him. More importantly, in our second victim, Tate, not only does this defendant slit his throat, but Tate's moving away from him. So within those seconds, that time limit that he has that he's moving away from him, this defendant still continues to have that thought that he's going to kill him by swinging a hammer and smashing him in the head over and over again. This is a case, if you go back and look at the Florida Supreme Court, multiple district courts of appeals, they would assert that this case has a super level of premeditation, not just the bare minimum of premeditation that's required. In the courts past, they determined that just taking a knife from a room and entering and stabbing someone 1 time was sufficient premeditation. So independent of the defendant's statements, which the state would say, Judge, his statements actually establish premeditation. If you listened to him yesterday, He knew he had to go in there and kill them because, according to him, he was sleeping with his wife, hurting the kids, harming the family. So he had a thought that he was going in there ahead of time. He made that conscious decision. So there's no question that premeditation for count 1 and count 2 is absolutely applicable here. Secondarily, if we address the defense's argument on burglary, first off, defense tried to argue that this is a burglary that is like going into Walmart and it's a store employee's exit entrance. You can't go in. That's exactly not what we have here, Judge. That would be entering with the intent. We have remaining with the intent, which is a completely different way of proving it. And the legislature in, I believe it was, I want to say 1998, they determined that, I'm sorry, it wasn't 98, it was 2001. They determined that the Supreme Court misinterpreted their legislative intent, what remaining in was. And they actually wrote something into the statutes. If the court needs, I can give you the statute number, but I believe it's...
I've got it. I reviewed it last time.
Okay, yes, sir. And it's 810.015 for the record. And in there, they specifically said that the Supreme Court had it wrong, and the 3 previous Supreme Court cases with the intent of what they meant by the remaining in is what they wanted. And then subsequent to that, Judge, I provided the court yesterday and the defense a 2015 case from the Florida Supreme Court that it speaks exactly on point to the situation we have here, Judge. The state would respectfully ask the court to deny it. This is a jury question for the jury. If the jury wants to determine premeditation, that's for them to decide. If they want to determine that he committed a forcible felony and he had that intent when he remained in there, then that's for the jury to decide, Judge, and we'd ask you respectfully to decline their motions.
All right. Anything else from the defense?
No, just that looking again to his statement, the repeated statements by the defendant regarding his actions clearly point to an impulsive overreaction and clearly refute the state's allegations within count 1 that this was a premeditated act. And that when we're dealing with an impulsive overreaction to this degree, that the second-degree murder count is what is appropriate. And we would argue that there's insufficient evidence as to what's before the court for the first-degree premeditated murder. And that's it. Thank you.
Thank you. Talking first about premeditation, going to the instruction that I'll be giving the jury fairly shortly, specifically reminds us that proof of premeditation is found if the circumstances of the killing and the conduct of the accused convince you of premeditation. Sadly, I've encountered this fact pattern before where there's an allegation that the individual changed weapons in the middle of a homicide, and I think that is strong circumstantial evidence. I'm not going to weigh it, but I'm going to say it is strong evidence of an opportunity to reflect and to form premeditation all by itself, aside from the other circumstances. Not conclusive, but it is certainly strong evidence. Secondly, the fact that there were 2 victims, as the state mentioned, does indicate the same opportunity, and so that is a jury question, and on that issue I'll do that to the jury. With regard to the burglary, I think there is sufficient evidence from which the jury could conclude that the implied consent had been revoked upon the actions of arming himself and beginning to take the violent acts that are alleged herein. And I think that we're trying to parse the statute much too finely to indicate specifically when he entered the part of the premises necessary. I think the entire house premises is sufficient for the burglary. The change of intent, the permission was granted to the entire house area. The change of intent that occurred happened while he was within that general geographic limit and is sufficient. So I'm going to deny that motion with regard to the burglary and with regard to the felony murder, which is inherent in counts 1 and 2 as well, because the state has alleged burglary as the felony. All right, let's talk a little bit about timing. We do have some work to do on instructions. My suggestion would be that I bring the jury in, we allow the defense to rest, state they have no rebuttal, and then we'll announce to the jury that they can take a lunch break
I would anticipate until 1:30 would be safe, 1 o'clock maybe?
Yeah, we can come back, I mean, earlier.
Well, we're gonna be working. We're gonna put them on an official break, and allow them to get some lunch, and then make sure that they have all their items necessary if they're gonna be sequestered. And then, as soon as we dismiss them, we'll, resume, discussion on the instructions. Anything else to take up before we do bring the jury back in?
No.
All right, thank you. Let's go ahead and bring the jury in, please.
All rise, jurors, enter the courtroom, please.
All right, thank you. Please be seated. Defense?
At this time, the defense would rest.
Thank you. All right, members of the jury, actually state any rebuttal. I'm sorry.
Yeah, you're right.
Thank you. All right, members of the jury, both the state and the defense have rested. They and I have some work to do on preparing your instructions. So what I propose to do at this time is take our lunch break, put you on lunch break until 1 o'clock. While you're on that break, you are not to have any discussions with any other person about the case. Same instruction as yesterday, no outside research as well. If you could, you have not already brought back your items to be prepared for sequestration this evening, bring those in when you come back from the lunch break. Any questions? All right, thank you. If you would step out, please leave your notes in your folder or on your chair, please.
All rise as the jurors exit the courtroom, please.
All right, thank you. Please be seated. Do both sides have the draft that I sent last night?
Yes, sir.
There's draft 2. And I'm going to summarize for the record the email that I sent asking you all to be prepared. The first one is that it goes to the forcible felonies named within burglary. Specific concerns I had were, first off, and I will tell you this first, has alleviated some of my thinking about it overnight. Way too much time thinking about it last night. I was concerned that aggravated assault is the threat only, but not the actual use of the weapon. But as I considered that at the point of entry, at the time of commencing the burglary, that the defendant had an intention to commit one of the enumerated forcible felonies, and so therefore whether he had an intent to do this, the aggravated assault, or whether something that involved actual contact is concern goes to the description. The four enumerated under burglary are aggravated assault, aggravated battery, that you've enumerated, the state enumerated yesterday, aggravated assault, aggravated battery, manslaughter, and murder. We had some discussions about whether we should be using the term premeditated murder with regard to those four enumerated.
And Judge, I thought about it last night too. I think it should specify out second-degree murder and also premeditated first-degree murder.
Okay, so we'll have to build those in as instructions. But let's talk about this. With regard to premeditated first-degree murder, don't we then end up in a circular argument? Let me explain, see if I make it clear for the record, that with regard to the first count, which is with regard to robbery, the two viable theories, and I did read the Spar case. I had actually read it earlier, and then when you sent it again, the two viable theories always in a count like this, without further enumeration, are the premeditation. Now, we premeditated intent to kill. As to robbery. The specified felony here is burglary. Within burglary, you've enumerated four possible felonies that he had the intent to commit upon the commencement of the burglary. One of those being premeditated murder. My concern was that premeditated murder.
Yes, sir.
And that's where, but I will tell you how they solved it thus far, and this is not found in the Supreme Court opinion. I went online and I pulled up the actual instructions of Judge Centerfit gave.
So did I.
Okay, so she was a lot less precise. She simply said during the commission of a forcible felony, and I think if I'm not mistaken, left it at that.
But they didn't define, I think their instructions were not as precise as ours would be, because they didn't even describe what a forcible felony was. I don't even know how the jury knew what one was.
You're correct, they did not, and that was, we'll leave that to another court for another day. But when we get precise is when we get ourselves into this circular conundrum that I'm seeing here. So go ahead, Mr. Lewis. If you see a way out of it, let me know.
I don't see a way out of it, but I think that the legislature intended when they described what a forcible felony is, they included first-degree murder. I was just about to quote what forcible felonies are in Florida, but they include murder, and I'm quite certain they include first-degree murder with that. They didn't actually pull that this
No,
morning.
it just says murder. That's the problem.
It does, but I'm quite certain that if they intended murder. So there's been other definitions, like when you look at the PRR and you look at other cases, what actually counts as murder. And they've determined, I've seen before where it's first degree murder and second degree murder all qualify under those definitions. I can search under Westlaw. I didn't actually look for that specific whether or not, but I'm quite certain if I search under 77608, I'm sure there's going to be a case that interprets first degree murder as being forcible felony.
Let me throw one other issue in the mix just for you to consider. Felony murder itself, when it enumerates statutes. Now we're in burglary here, and this is the problem: is we have a crime that's enumerated that also has embedded proof of other crimes that are necessary. But felony murder itself, if it were alleged, it speaks of murder of another person. But that's not exactly where we are here, and I understand that.
But we did allege that too, just the court notes. In our indictment, I reviewed it this morning. We did allege a burglary and or the murder of another human being. So we do have both,
so
that
so
language
one
is both in there.
So that one is already.
It's
actually the second. It's actually the second. Now that you're right, okay. Now that you think about it, it's the second theory that you're proceeding under. Good point. Mental note about that. Thank you.
However, Your Honor, that second theory is not premeditated murder. So we really are, at a minimum, we're gonna end up using the jury, but essentially the judge said just adding premeditated murder within the burglary charge.
I'm not sure I understand your objection, particularly given the language of the count in the indictment.
Right, the indictment is to end or murder of another human being, it's not to another premeditated murder. So this burglary and or murder.
Well, I'm not sure why you're making this objection, because the state's making it harder on themselves. Because they're requiring that in order to prove the felony murder of Robert, well, they've asked for premeditated as the underlying.
Well, we wanted
But you also
premeditated
want
second
second.
degree murder, we want manslaughter, aggravated battery, ag assault. We want all 5 of those because they're all forcible felonies that would equally apply. I think from the facts, Judge, a reasonable jury can infer, even if they don't infer that he had the intent to commit premeditation, he went in there with weapons. So at the very least, he was going to threaten them with those weapons. Obviously, we know he went much further than that, and he completely attacked and killed them. But if the jury for some reason says, Ms. Dutton, Mr. Lewis, we don't think Mr. Wilson went in there to actually kill them, but he just went in there to scare them with the weapons, then it would still qualify as a burglary, and he'd still be guilty of felony first-degree murder. But as the Sparrow case says, in that case, if you, as you read, Judge, he was convicted of first-degree premeditated murder and first-degree felony murder. So in that case, he was convicted on both, and there was a jury form that actually, it was specific findings in that case. So I think the Sparrow case talks very specifically to our case, because I think we're entitled, and Ms. Dutton's looking right now to see if a forcible felony qualifies as a first-degree murder. I just can't fathom in the legislature's intent that it wouldn't qualify. And they didn't, and there's no exclusion in the burglary statute that says forcible felony except first-degree murder. So we have to go by what the legislature intended.
Forcible felonies, the tail end of the definition is the broadest of all.
Yes, sir.
Because it talks about violence against any person.
Yes, sir.
It's as widely inclusive as you just about can get. So I'm not concerned there. And realistically, my concern is not necessarily on what theory you proceed under. It's whether when we get to it, the verdict form is going to be specific enough. And that goes to the second concern from my email. When you present alternate theories, you present the specter that 3 jurors could find that he was going into the house to commit burglary with the intent to commit assault. 3 others would find an aggravated battery. 3 others would find murder. That's not a unanimous verdict. That's an argument that could be made later on appeal, because we have the multiple theories out there. Understand they existed in SPAR and it wasn't raised there, but I'm aware of that line of case law that talks about.
So I can tell you I've researched this issue recently, Judge. There's absolutely no case law on this, the issue you're bringing up. But what I will tell you is there's case law that the jury can go back there and 6 of them can find for premeditated murder and 6 of them can find for felony murder, and that is still a lawful unanimous verdict. I think Ms. Peoples actually was involved in a recent decision that had occurred where the jury had a strange jury questioning where it turned out that they weren't unanimous on one or the other, but then they still convicted of first. And there's multiple cases that say it doesn't matter if 6 people want felony murder, 6 people want premeditated murder, it all fits under first-degree murder. So the theory of who they convict doesn't matter. So my argument with the court would be is if the Supreme Court has already made that decision in reference to 2 distinctly different murders, which is one premeditated and one felony, that the theory under felony murder is much more akin to being similar than premeditated and felony, so that the Supreme Court certainly, if you look at it, they're going to find that that is an applicable way of finding it, because those degrees under the felony murder all fall under first-degree murder, which is the panoply of what they decided their decisions on. And if you need, I can find the cases. I did read them.
So your theory then is, if I can restate it in a way that makes sense to me, is that as long as the jurors all found a sufficient level of underlying crime, because we're 2 levels away here.
Yes, sir.
From the crime we're talking about. We're talking about elements of one element of felony murder. if sufficient jurors found that he had committed a felony, therefore, or one of these, and not even a felony actually, because our burglary, Florida's burglary does not require a felony. If he has committed another crime, you're saying they don't need to agree what crime, just that he was planning to commit another crime at the time of the burglary, and is sufficient then for burglary, which is sufficient for felony murder.
Yes, but I don't say just another crime. I say it has to be a forcible felony, one of those 5 forcible felonies that we're talking about.
Okay.
Not just any crime, because you know how we charge an offense. This part of the burglary statute we're relying on is much more specific.
But as long as they all agree to the, not the first level analysis, but the second level, he committed a burglary which required
Correct.
proof that he intended to commit one of these 5. Doesn't matter which of the 5 they don't all have to agree on which of the 5.
I don't believe they do, Judge. Obviously, I don't have case law for you because I did research this recently. We had a felony murder out of Volusia where it was kidnapping and one other, and we didn't have the jury delineate which one it was. They could have found under both of those theories. The court, Judge Nichols, didn't have a jury verdict form stating it was kidnapping. I want to say it was sexual battery, charged kidnapping and sexual battery, and the jury was not instructed on that they have to make a specific finding about the theory, just that they just have to find the felony murder.
All right, so the specific on the instructions then, and going to our draft instructions, what you would be looking for then would be that under felony murder, that I instruct them on burglary, and the theories of burglary were the 4 that we talked about yesterday, right? The aggravated assault.
Yeah, so we talked about
the underlying intent theories.
the intent to ag assault, ag battery, manslaughter, second-degree murder, and first-degree murder.
And that would be over defensive there.
And of course,
I understand, and I haven't even heard from your side yet, other than know you're objecting, that's fine. And then with regard to, but they also could find, without burglary, they also could find a separate first, second, or manslaughter as the underlying felony of the other individual.
Yes. Under the premeditation phase, or?
No.
Oh.
Think of this like an ancestry tree. Your murder theory has two supports, felony murder and
Yes, sir.
premeditated. We'll push premeditated off to the side. Now we're going to just look at the felony murder side. You've alleged 2 underlying felonies. Murder of another.
I don't necessarily know if we want to go on the murder of another. Let me talk to Ms. Dunn. It's too confusing to explain it to the jury. I think for us it's much more crisp and clear to go under. Let me just ask Ms. Dunn. Yeah, Judge, we're just going to go under the burglary as
Just
opposed
under the burglary.
Yeah, because that's much crisper and clearer for a jury.
And I understand that's your choice to, I'm not talking you in or out of it.
No, sir.
I'm just saying that that's a choice you're going to make, and we're only going to instruct on that theory then.
Right, and that's
only burglary with the intent, his intent necessary for burglary to commit one of the now 5 enumerated offenses.
Yes, sir.
Now, with regard to those enumerated offenses, and when we specifically get to the premeditated, which is the first degree, do we need to lay it out the way we have in our current draft, where, well, actually, we don't have it laid out, and that was one of the questions from my examination last night. But do we have to lay it out as we have currently done in the primary instruction on premeditated, that Robert Baker is dead, death was caused by criminal act of Mark Wilson, there's a premeditated killing of Robert Baker. Could it not actually be Robert Baker? Isn't it actually both at this point?
Yes.
Okay, so it should be Robert Baker and/or. This is one time when it would be permissible. I hate using the and/or construction.
Sure. Right.
But it would be Robert Baker and/or Tate and Baker are dead, is dead.
is/are, because it could be both.
So you're saying, Judge, just so I follow you, that like the jury could look at an ag assault, a manslaughter, an aggravated battery against Tate, but use that for finding him guilty of felony murder against Robert. I see. Yes, sir. That's fine, Judge. I think that makes sense, actually.
I'll have to do some writing there. All right, Ms. Peoples, you've got some concerns. Please share them with me.
Your Honor, what the state is proposing,
Could you please speak up? Because I can
Sorry.
hardly hear you. I'm sorry.
what the state is proposing is confusing. Even in these discussions, it's getting confusing, and I do understand the court's pointing out the advantages to the defense with this, in terms of the level of confusion that they're creating, but the indictment, it's identifying that the first decedent is Robert and that the felony murder, burglary, another human being right after that is also RB. So I've always took this to mean that the felony murder was addressing Robert in count 1, and that the first degree was Robert in count 1.
So
now I'm hearing that they're introducing Tate.
well, I'm not sure I may have talked them into it, and I don't want to talk either of you into it. Let me make sure, if you're asking me just to instruct on Robert, then we rely in that case on the holding in the Sparry, S-P-A-R-R-E case, which says that premeditated murder of one, the facts of that case sufficient for us to discuss here are that there was a murder of an individual, very similar charges in fact here. But in that case, only one individual. And so the state was allowed to instruct and received an instruction on both the premeditated and on the burglary as an enumerated felony for the purposes of felony murder. And under that, they simply, and this is where they were very vague, they just simply said forcible felony. And that was never challenged. We're not gonna do that. We're gonna give them more instructions. But you're saying you're not objecting to the fact that the premeditated murder that the state wants to instruct upon is just Robert in count 1, as in for instance.
Yes, right, it's to count 1 is
Because of the language
now-
of the text of the count.
But here's what I'll say is I think what I follow from the court, and maybe if I can explain it. So in order for a burglary to occur, it's not an individualized burglary against Robert and Tate. It's the burglary of actual residence. So if Mr. Wilson formed the intent to commit an offense, which would have, let's say, murder, and his intent was to murder Robert, but he also, went over and killed Tate, but there was no premeditated intent. I do follow the court's logic that the and/or would be applicable because it applies to the burglary, not to the actual
Did unlawfully from a premeditated design to effect the death of a human being, kill and murder RB, comma, a human being, comma, by hitting him with a blunt force object and or using a sharp force instrument to slit his throat, comma, and or while engaged in the perpetration of a burglary and or murder of another human being, comma, RB was killed. So I don't think that RB was modifying the another human being. So I think notice that another human being, who else would another human being relate to in a charge that's about Robert?
Of course.
But it would be Tate, would it not, Ms. Peoples?
Your Honor, I understand, I see the comma, but the point of the instructions is to assist the jury in rendering a verdict, and what is being created is causing confusion across the board. So we're objecting.
Well, that's my job to unconfuse it, so that's my task.
Right, so
And I need your assistance, so. All right, I understand your objection. Let me, in going to that particular point of the instruction, let me focus your attention then on a page of the instructions draft.
So we're talking about felony murder, which puts us on 5 and 6 of the instructions. So the last paragraph right above the word burglary is one that I've modified slightly. So the court will now instruct you concerning the definition of burglary as it applies to the crime of first-degree felony murder as charged in count 1 of the indictment. Then we just give the description of burglary. And I've related here, and I added language in this next paragraph that specifically, hopefully, focuses the jury's attention on what they're doing here. To prove the crime of burglary as it relates to the second element of first-degree felony murder in count 1, the state must prove the following 2 elements beyond reasonable doubt. I'm actually thinking, and I've thought this morning, and I'm going to play with this a tiny bit and give you another draft shortly. We want to focus the jury's attention that their inquiry here is not as if these were separate crimes, which they are, but their inquiry here is on the intent. That is what they are focusing on here. I don't think there's ever been any, I'm not even 100% sure that they have to find any of those underlying crimes beyond a reasonable doubt. They have to find there was intent to commit one of those crimes. So I'm not even sure that that language about must prove the following 2 elements beyond a reasonable doubt is correct.
Well, it does say in count number 2, it says with the intent. So we would have to prove beyond a reasonable doubt the intent, but not actually the success of the crime.
Correct. It's intent that we're looking at.
Yes, sir.
Your Honor, I'm sorry, but the burden would still rest on the state to prove the
Absolutely.
beyond. So if an element of burglary, if there's a 2, then we had asked that they're instructed that they have to prove up both. And I might be missing something. I just thought I heard that state didn't have to prove an element.
No. This is not an element, and that's the point. Let me go back for a second to the Spar case up in Jacksonville, about 5-6 years ago. Judge Senership gave instructions that simply said, and these instructions made it past Supreme Court scrutiny.
Yes, sir.
She simply said that a burglary, the state has to prove the existence of a forcible felony, the intent to commit a forcible felony. That's it. That's all she said. Stop, period, end of paragraph, no further description. Didn't describe forcible felony, that concerns me. Didn't enumerate or describe any of the underlying offenses that would constitute a forcible felony, that concerns me. And that's where they ended. So here, we've done that. We've gone in and we've enumerated a list of forcible felonies. And we also need to describe them. And the language from the precedent cases specifically says, describe the forcible felony sufficient for the jury to understand it. It doesn't say that the jury has to make beyond reasonable doubt findings about that underlying forcible felony, because it might not have ever been committed, like aggravated assault is not present here. This is all talking about state of mind at this point. And so that's where I'm wrestling between giving them a whole lot of information, which may be too confusing, and giving them too little information, in my personal opinion, reading the law and providing for a fair trial. And I don't think the state disagrees that there should be more information than just saying forcible felony.
Sure. I mean, if you just say forcible felony, it's that's.
I just have to make a distinction, because the case that they're talking about, in which I was involved with Caleb Scott, and the underlying felony was child abuse. And it wasn't an issue of other individuals, it was one victim. The one offense was the homicide, and then the felony murder was the child abuse. Right, so there's a distinction there.
I understand
yes,
that.
the jury was split, but there wasn't that opportunity to split in terms of, well, we're talking about this decedent in count 1 versus meaning Tate in count 1 as the underlying to the felony murder is what the state's proposing. So I'm just saying there is a distinction with what happened in Voluntary versus what could occur here today in this case.
And I think what I was just saying in Voluntary is you had premeditated and you had felony murder, and the jury split on which theory they actually agreed with.
One victim.
Right, one victim. But we're not saying. What I'm saying is you have to look at what the actual crime is here, which is burglary. And burglary doesn't require, it's not applicable to each individual victim. It operates on the house or on that place. So if I have the intent to commit an offense against, you know, somebody else in the house, but during the course of that I kill somebody else accidentally, I'm still responsible, because even though I had the intent to, you see I'm following me?
I am, I'm
Okay.
just trying to make sure you understand that what happened in Blue Show was one victim, and what you're proposing here is that we're addressing a second murder victim in count one under the felony murder.
Well,
So
malicious
if you split
has
the
nothing to
verdict-
do with this.
Right, so I just heard you say no Dr. Londu, because if you get a split verdict here, we're gonna have a problem. So that's what I'm addressing. Because if the way you have this is that it's premeditated sort of, Robert in count one, and then the underlying, or the felony murder, from what I'm understanding now, because I always thought it was Robert, but the underlying felony murder would be to Tate.
No, so you're not following. The underlining felony is burglary. So it's to commit, the intent to commit ag assault, ag battery, manslaughter, second degree murder, or first degree felony murder, premeditated murder.
So you're not arguing it's Tate in count one?
No, we're gonna.
Meaning the underlying.
No, we've receded from using, so where it says burglary and or a human being, we're not gonna argue the human being portion, because that's two ways to prove it under the felony murder. We're just going on burglary because it's much cleaner and more easy to understand.
That's what they're doing, Your Honor. That's simpler, because I was starting to get like a spaghetti diagram as to who they're going with. But if the
It's my job to sort out those strands,
Right.
so that's what I'm trying to figure out here. All right.
Whatever the court, we'll see what the court comes up with, then we can
Yeah,
talk about it.
I'm gonna work
Yes,
on
sir.
that. All right, let's, writ large, remaining of the instructions other than what we've already talked about. Were there any corrections or concerns specifically?
Yes, Your Honor. So, we've asked to strike the ag assault instruction for lack of evidence. The aggravated assault instruction, but
State, if you would address that?
Yeah, the state obviously doesn't disagree, Judge. I mean, disagrees with that. I've already articulated before, Judge, it's not the actual murder itself that could cause the burglary. It's that he had an intent to, let's say the jury believes he had an intent to commit an ag assault because he was upset with them harming his family. The fact that he armed himself with 2 weapons and went in there, that is sufficient enough to show the aggravated assault. And certainly it's for a jury to make that decision. You know, and they may say, you know what, we don't think he had premeditated murder, but we think he had the intent for aggravated assault, so we're going to find him guilty of felony murder, but not premeditated first-degree murder.
I would stand on the, Your Honor, it's trying to.
I can't hear you. I'm so sorry.
No, thanks for your time. No, we're trying to simplify, and provide instructions to the jury that are pertinent to the charges before them, and that in this particular instance, especially in light of no one is addressing that anyone was awake at the time of this, this incident, that the aggravated assault wouldn't apply.
All right, I'm going to deny that motion. I'm going to keep the aggravated assault instruction in. Understanding my job is to make it clear in the instructions that it goes to his intent at the time he commenced the burglary. He's not charged with aggravated assault. It's just one of the theories of intent.
And then, lastly, Your Honor, defense, I provided the citation yesterday for Perry v. State, and the reason why I provided that citation was in support of the request from the defense to remove voluntary intoxication instruction. In this particular case, there's been no testimony from the defense raising intoxication as an issue. It's come through in the state's presentation of the defendant's statement on the 27th scene. So, since the defense did not open the door to voluntary intoxication, we'd ask that the jury not be instructed on voluntary intoxication, and the defense has no intent in closing to argue intoxication as a defense.
Do you have the citation for that, for Perry?
Yes, Your Honor. 256 Southern Third, 888, and it's a 2018 case. So the defense is not trying to argue at any point for intoxication in this particular case. So that's why we'd have to have a voluntary intoxication.
Steve?
First off, I just want to address, because the defense has already argued in the judgment of acquittal.
Not before the jury.
I understand, but I'm just making sure. So the defense is not going to get up there at all and mention anything about any drug use at all. Because if they do, I believe it's relevant, Judge. If they're going to agree, we won't make any argument, we won't even dance around it. That all they can, I guess they can argue he was up for 3 days, but they cannot mention the drug use. If they do, then we think it's relevant. And the case the defense cites is not really actually on point, Judge. It's a mental health case. It's a little bit different. So, I mean, if we need to argue specifically on that, but if they're committing to not arguing at all about drugs, then, and they're not going to even infer to it, not dance around it, then I think we'll be okay. But if they are going to mention it even off a glance, I think we're entitled to that instruction.
I confer to counsel and confirm there's no intent to argue drug use or intoxication as part of the closing.
If I see it, if I hear it, I'm going to give the instruction, and I'll give it after your closing if you open that door back up. But for right now, if you're assuring me that you're not going to go that direction, I'll leave it out and potentially include it later. Mr. Lewis, anything else?
Just talking to Ms. Dutton, we do believe it is in evidence, though, based on his statement, that, and the jurors could have that in their mind, and they might write a question and ask us.
There's a line of case law that talks about, even though the defendant doesn't testify, and I don't know that it applies to this issue, but even when the defendant doesn't testify, the fact that there's been statements that have come in through another source, they can then be alluded to. But I think, doesn't that case law specify that it's the defense that actually introduces that alternate source information? Like
We have not
a family member says, no, I think the line of case law, doesn't it? I don't have a case name.
And that's
maybe
what
right now.
Perry is for. And the counsel's correct, this is predominantly dealing with chestnut and mental health issues.
Okay.
But it's there for that to support the defense argument that we did not introduce mental health and we did not introduce intoxication.
So you're not going to argue then corresponding?
Right,
Right.
not in this case.
All right, I understand that. All right, well, I'll take a look at that case. Anything else then on the instructions?
No, Your Honor.
All right, I've got a little bit of writing to do, so I'm going to get to that right now.
Can we look at the verdict form, Judge, just make sure we're all in agreement about that too, sir?
The only question I had about the verdict form I'll share with you all is, I don't typically put on a verdict form the statute numbers that were violated. That's why I had them highlighted on the,
You can take this out, Judge. That's fine.
unless somebody wants them in to show some specificity, but.
Yeah.
The jury's not going to have a
That's the
statute
point,
book
is
back
it
there
also
anyway.
it would beg them to do some research they're not called to do. So I'll take those out. I did build in the instruction on trespass while armed as a lesser included on burglaries.
I saw that. Thank
Last
you,
night.
Judge.
You already had that as the lesser included in the verdict form.
Right.
Interrogatory. There is, in the trespass while armed, or I should say just trespass, there is a further aggravator apparently that may apply if the property is occupied. And I don't know if that applies in this case. I left the instruction in because in the model.
I don't think it matters, because that one would take it from a second degree, I think, to a first degree maybe, but we're going from a first degree misdemeanor to a third degree felony by using the weapon as the enhancement. So
there's no,
unless the defense wants it, we're okay with it not being in there, but if the defense wants it, we have no issue.
Vince, do you know where I'm talking about in the trespass instruction?
See on page 40, it's 40 to 51.
That might be one place. It's probably in two different places.
But the judge is also talking to the verdict form.
Yeah, so on page 34, look there first if you would. On page 34. The third full paragraph. If you find the defendant guilty of trespass, you must determine whether the state proved beyond a reasonable doubt there was a human being in the structure at the time of the trespass. As Mr. Lewis suggested, that would be an aggravated, it takes it to from a second to a first degree misdemeanor, right?
I think it's a second degree misdemeanor as here, and then it would take it to a first degree misdemeanor.
Right.
But any trespass with a weapon is automatically a third degree felony anyway. So if they want an extra, they already have a second degree misdemeanor on the table. If they want a first degree too, we don't care.
I'd have to add the interrogatory, that's all.
That's true. Yeah, I'm just saying whatever the defense wants, we'll defer to them.
I'm just trying to see where it is on the.
Well, it's not there yet.
Oh.
It would be a second interrogatory under trespass of the structure, because the first interrogatory is what raises it to the third degree felony. If I put another interrogatory in, it would only matter, it only matters, well, they can make the factual finding, it's an Apprendi finding, and it would be necessary to raise it from a second degree misdemeanor to a first degree misdemeanor.
Your Honor, and. But it's already here, trespass while armed, yeah, while in the structure, it's already added. Are you asking if we want it?
No, armed is already there. What I'm talking about is whether the structure had another human being in it.
Oh.
It becomes occupied versus unoccupied structure.
Your Honor,
That's,
there's no debating if it was an occupied structure.
but it's still a if,
What the judge is saying is if they come back and they find that it's only trespass and he's not armed, then they would check second degree misdemeanor. It's a second degree misdemeanor. But there's another option where it was occupied, so it'd be a first degree misdemeanor. If you want an additional misdemeanor, I'm not sure.
It's fine, Your Honor.
so you waive that, you don't want that option in there?
No.
It's either trespass, essentially unoccupied, second degree misdemeanor, or trespass while armed, third degree felony.
Yes, sir.
Okay. All right. And I'm Switzerland on this. I have no particular desires either way.
Is
Just
there,
let me know.
it's just the one line to say occupied that would be added?
It would be an additional interrogatory. Please answer yes or no. It would be, if you find the defendant guilty of trespass in the structure, do you also find beyond a reasonable doubt? Well, actually, it would just be one more interrogatory. While in the structure was occupied by another human being, yes or no?
That's fine. Yes, please add that.
Include that? Okay.
All right, parties are again present, defendants present, jury is not. Sent you all a copy of the verdict form, and then I found a little mistake on a little highlight on it. The physical copy, I just handed to you, has that corrected. Also giving you 2 copies for the defense table, 1 for the state. Final draft to go over of the instructions. Let's
On the 4th page of the verdict form for count 4, we just asked to remove the word firearm.
Okay, got that. Any other corrections on the verdict form? Remove the word firearm. State any other corrections? Sorry, verdict form.
No.
Defense.
No, Your Honor.
All right, let me, I'll email that to you as well.